Welcome, everyone. Before we begin today's presentation, please note that this seminar is being recorded and closed captioning is available. If you wish to turn on closed captions, please click the Show Captions button at the bottom of your screen. Thank you, and we will begin shortly.
Hello, everyone, and thank you for joining the University Hospital Foundation's virtual estate planning seminar, proudly presented by Bryan and Company, LLP, and Edward Jones. My name is Chaylene, and I am the Director of Philanthropy at the University Hospital Foundation. I am so happy that you can join us for this event. I would like to first acknowledge that the University Hospital Foundation is located on Treaty 6 territory, and we respect the histories, languages, and cultures of First Nations, Métis, Inuit, and all First Peoples of Canada, whose presence continue to enrich our vibrant community. As Emily mentioned, today's session is being recorded. We will send the link to everybody who responded to our invitation over the next few days. Today, we are going to hear about the benefits of estate planning, how to get started, and how a legacy gift can help you achieve your legacy goals. For your benefit, we will have a Q&A session at the end of our presentation. Please do submit any questions that may arise during today's presentation through the Q&A button at the bottom of your screen. Our legal and financial planning experts will attempt to answer as many questions as possible. Now, to tell you more about the work we do and why we do it, and to introduce our very special guests, I would like to welcome one of our own Agent of Hope leaders, our Chief Development Officer here at the University Hospital Foundation, Sean Price. Sean?
Thank you, Carolyn. It's a pleasure to be here today, and exciting to see so many people interested in learning more about estate planning. The bold purpose we have set for ourselves at the University Hospital Foundation is to transform and redefine health. We know that's not going to happen overnight, nor will it be easy. We also know that it must happen. Healthcare teams and researchers at the University of Alberta Hospital are simply amazing. They save lives, they provide extraordinary patient care, and they make breakthrough discoveries that impact the health and well-being of people right here in Edmonton and around the world. But they cannot do any of that without the generous support and ongoing community support. In the past 10 years, donations from individuals, corporate partners, and legacy gifts have contributed nearly $275 million towards bringing some of the best patient care in the world to our hospital site, benefiting people of all ages. Our hospital delivers life-saving care to people facing brain, cardiac, gastrointestinal, and neurologic conditions, just to name a few. Through our donors, we provide our medical teams and researchers with the technology, equipment, and ongoing financial support to advance patient care, create new knowledge, and inspire breakthrough discoveries that impact health and healthcare around the world. That's the good news. The bad news is, and some of you may know, heart disease, stroke, sudden trauma, they continue to devastate families every day. Waitlists for transplants continue to grow. And research to find answers for debilitating brain conditions such as Alzheimer's disease and multiple sclerosis must continue. As much as we have done, we have so much more to do. The best and only way forward is working together with our many private and public partnerships, healthcare teams across the spectrum of care at the University of Alberta Hospital site, and of course, our committed and dedicated donors. I'd like to share how each of you can become a member of our proud and very exciting Gold Leaf Society, where you'll receive exclusive updates, invitations, and recognition from the University Hospital Foundation. When you share your meaningful intention with us to leave a bequest in your will to the University Hospital Foundation, you automatically become a Gold Leaf Society member. This means your gift will not only be remembered by the patients who benefit directly from your generosity, but also by the future generations of Canadians who may not know who you are, but will be inspired by what you have done. If you'd like more information on our Gold Leaf Society, please visit our website at givetouhf.ca/goldleafsociety to learn more. I'd now like to introduce our special guest speakers for this afternoon, Mark Claffey and Chaylene Gallagher. Mark is a local investment advisor with Edward Jones and holds board positions with the St. Albert District Chamber of Commerce and Hockey Alberta North Zone Referees Committee. He works closely with individuals who have complex financial needs, including business owners, self-employed professionals, and upper management employees. Chaylene is a partner at Bryan and Company LLP with primary areas of practice in wills, estates, labor, and employment. She assists her clients with estate and succession planning in conjunction with other advisors. She also provides litigation services when estates go awry. Chaylene has attended at all levels of court for estate litigation. She is a sessional instructor of employment law at the University of Alberta and is a member of the Canadian Bar Association. She regularly volunteers with Student Legal Services at the U of A and dedicates time to other charitable legal initiatives. She's proud to be affiliated with the University Hospital Foundation along with other health organizations within Edmonton. Mark and Chaylene, we're very excited to hear from you both about financial and legal planning today. I'm sure there'll be plenty of questions for you both during the Q&A at the end of our program. And on that note, a reminder to everyone, please submit your questions in the Q&A box at the bottom of the screen, and we'll attempt to answer as many as we can during the Q&A session. So Mark and Chaylene, the virtual floor is yours.
Terrific. Thank you, Sean. And a huge thank you to everyone at the UHF involved in organizing this event and inviting me to speak. I'm excited to be here. And yes, you heard Sean right. In addition to my day job as a wealth advisor, I am a referee for high-level hockey in and around Edmonton. This is, year 11 now. So if you're okay with it, please hold your booze until at least the end. I'd appreciate it. But yeah, so today, Chaylene and I will be discussing a pretty complex topic in all of our lives, and that's estate planning. And there's a lot to do and a lot with it. But before we dive in, I thought it'd be interesting to get a sense of where our audience is with their estate planning. So you should see a poll on your screen pop up any second now. When was the last time you reviewed your existing will? You've got four options. So either number one, you don't have a will, number two, within the last 5 years, number three, within the last 10 years, or number four, over 10 years ago. So please choose the option that best represents you, and we'll see what the results look like when they come in.
The results are coming in. We will give everyone about 10 more seconds.
Yeah, it's as expected. So roughly about a third, a little over, third of you answered you don't have a will. Another roughly third have reviewed it within the last 5 years. Good on you. And about 15% each for a little over within the last 10 years and over 10 years ago. So it's pretty common. That's actually a low number lower number than I expected for not having a will. Typically, it's about half and half. So good on you for being in that spot to our audience. So Che, what do you think? Is that pretty consistent with what you see?
I was pleasantly surprised to see how many people have a will as well. We'll talk further today about when and why you might want to review your estate planning and what you might want to have in addition to a will. But over a third is pretty low, actually.
Yeah, I thought so too. So well, let's dive in to why we all need a proper estate plan. Now, first off, depending on your situation, developing the right strategy should be a team approach first and foremost. Now, two members of that team are two people on the call today, your financial advisor and your lawyer. Now, with that in mind, my plan today is to share some pretty common scenarios with you, and we'll get Chaylene to talk about what these people could have done in these scenarios to ahead of time to protect themselves and their families. And afterwards, we'll take a little time to discuss some common estate planning issues, and giving strategies from a financial side. And then I'll pass it over to Chaylene to share some of the more important legal aspects of estate planning. Next slide, please. Now, in addition to your financial advisor and your lawyer, another member of that team could include your accountant, especially if you're self-employed or if you have more complex issues to deal with. Since most of us investment advisors, we're not tax professionals, we'll defer to them for specific tax advice. And another very important member that I think is often overlooked could be the back office of your investment firm. I can't speak to other firms, but at Edward Jones, we have what we call our client consultation group, which is a team of individuals with legal, tax, and estate planning expertise. And they don't replace any other member of the team. Rather, they work with our clients' accountants and lawyers to come up with options that maybe haven't been considered. Really, they're an enhancement overall to to situations where needs are a little more complex. So again, a team approach really helps solidify a solid, strong plan. Next slide. Now, estate planning is, I consider it to be one of the most important yet often overlooked aspects of our financial strategies. And as we saw from that poll, again, the numbers were lower than we expected, but many of you and many Canadians in general have never looked into putting together an estate plan or haven't visited it in quite a while. And since you're on the call today, I'm guessing most of you have questions about it. So our goal is to address some real common questions and some interesting methods to do so. Next slide. Now, a fact that many people don't consider with estate planning is that even if you've taken no action at all, no will, no power of attorney, no personal directive, nothing, you still have an estate plan. In other words, even if you choose not to decide, you've still made a choice. The only difference is that instead of you deciding what you want to happen while you're still able to, the government will step in, apply a formula, and make those choices for you. Depending on your situation, it might work out fine, but their broad formula may not get the result that you would have been hoping for. Plus, it's an extra job for your executor and usually costs a little more money as well. So we'll dive into some stories today that might seem familiar to help address these concerns. And hopefully by the end, you'll learn about all sorts of options that you just didn't know existed. Next slide. Now, estate planning can be pretty uncomfortable to talk about, right? The topics of death and incapacity of ourselves or our loved ones, they don't exactly inspire emotions of peace and love, right? So I'm curious, and no need to raise your hand or anything like that, but just think to yourselves, have you ever had a discussion with family members or your beneficiaries about your wishes if you were to pass away? Now, I'm going to guess most of you are thinking, that's crazy and none of your business, Mark, which is fair, and none of their business. So some of you, though, I'm sure have had those conversations, and your beneficiaries do have a pretty clear idea of what you want to happen. To each their own on this. There's really no right or wrong answer. The point I'm trying to make is that these are difficult and emotional subjects for almost all of us. Now, I'm sure none of what I've discussed so far comes as a surprise to Chaylene. I've known her for years, and I know she's seen it all and then some. So let's move on to those scenarios and see what she has to say about it. Next slide. So for scenario one, I hear it all the time. We don't have an estate, so we don't need an estate plan. Well, the truth is actually a bit more complicated than that. You do have some form of assets right now, and you have the choice of deciding how those assets will be dealt with when you're unable to. An estate plan isn't just for the rich and famous. It's simply a set of tools that puts you in control of your personal and financial matters. It also addresses several other important items. Three great examples are: number one, guardianship for your kids. Someone has to look after them if you're not able to. Number two, when will your kids get these assets you've left them? Are they going to get a big check at 18 and have the summer of their lives? Or will it be doled out at specific ages for specific purposes? And number three, a tougher one to think about, but when to let you go, for lack of a better term, if you get very sick or hurt and are not getting better. If you don't decide and put it in writing, you could be putting a loved one in a situation to make that very difficult decision for you. So what I'm getting at here is that there's a lot more to estate planning than just where does the money go. Next slide. So on to the first scenario, we'll meet Claire. Claire's husband Thomas passed away a few years ago, and she's about to enter retirement. Her main goal is to spend more time with her 5 kids, and especially with her grandchildren. Claire and Thomas were never super wealthy, but they did manage to pay off their house and build up more than enough retirement savings to last her through retirement. Two very important goals for her are to help pay for her grandkids' post-secondary education, and when the time comes, pass the assets on to her kids without too much hassle. Unfortunately, as I'm sure many of us have seen, Claire got very sick shortly after she retired and passed away at 68. While she didn't get the opportunity to enjoy a long retirement, the question we'll address today is if there's a way she could still meet those other goals of helping her grandkids with school and easily passing her assets on to her kids. Next slide. So, Jay, I'm sure you've seen this play out before, and I'm sure you've seen times where there was a plan in place and times where there wasn't. So, specific to Claire and those two stated goals, what could proper estate planning look like for her, and how might things play out if she had no estate plan?
Yeah, absolutely. Thanks, Mark. When it comes to Claire's estate, it's honestly a sad story that we hear all the time. Someone thinks that they have best laid plans. They think they have a long runway for those plans, particularly when we're talking about little grandkids. And then unfortunately, that runway is sadly cut short. So we like to make sure that we're planning for best case scenario and worst case scenario. Normally, if we were speaking to someone like Claire, we would talk about sort of the easier stuff, the more positive planning, which is how do you want to support your grandchildren? How do you want to support your children? And how to balance those two initiatives. One of the more difficult conversations that we would have with Claire is what happens if one of those children does not outlive you? What happens if those grandchildren are under 18? Playing off of what Mark was saying, we would talk to them about how we want to financially plan for those grandchildren. What happens if there's a divorce within one of those family units? What do you want to happen to your legacy in that instance? So hopefully by the time that Claire has retired, she has long decided and had those conversations. So post-retirement, she doesn't have to spend her time in those difficult conversations with her family. The stated objective of caring for her children or her grandchildren's education, we would really want to talk with Claire about what that looks like. It's something called encroachment, and we can be pretty creative on what that looks like and how she wants to direct those funds for grandchildren's education. So those would be the main considerations for us.
Perfect. Thank you, Jay. And yeah, the main theme sounds like preparation ahead of time, right? She's got 2 main goals. She wants to handle it. There are ways to do it. But without that, those meetings and discussions ahead of time, it's unlikely they can actually happen as she wanted them to. So let's move on to scenario 2. Next slide. And this one's aptly titled, "It Won't Happen to Us," right? That thought that we never say out loud, that unconscious that drives our decision to get around to it one day. Next slide. Where we'll meet the Kapoors, Sanjay and Nisha. So they've been married 13 years, and one night they hired a sitter to watch their 2 kids, Rohan and Neha, so they could go out and celebrate Nisha's recent promotion. Their decision for Sanjay to work part-time while Nisha pursued her career had finally paid off. Well, a storm picked up throughout the night, and on their way home, a large truck crossed the center line and hit their car head-on. Nisha did not survive the accident, while Sanjay did survive, but was left with a severe brain injury and ultimately disabled. Next slide. This is obviously a tragedy, and for the Kapoors, there are a lot of questions. Who will pay for the funeral? Who will cover Nisha's lost income, pay the mortgage, meet Sanjay's medical costs, take care of the kids? Who takes care of investment decisions like planning for the kids' education? So, Chaylene, I'll defer back to you. Again, like I said, a tragedy, but same idea as before. Can you speak to what would happen if their estate plan addressed this, these aggressive scenarios, and what it could look like, and what would happen if they didn't?
Absolutely. And I mean, these are really tragic scenarios. We have to get pretty morbid with our clients. I usually try to use a joking example scenario to get everyone talking, but this one would be tough. I will say one of the very first things that we would discuss with our client in pre-planning for a potential catastrophic event is speaking with their financial advisors. There's a lot you can do outside of your estate to protect for something like this. I'll speak about it a little bit more from a legal perspective when it's my turn. But you can pass a lot of assets outside of your estate with your financial advisor to make sure that someone's taking care of your kids. Now, in this situation, if there was no proper estate planning, the biggest issue would be the vacuum. So if there's no proper estate planning and neither parent is able to make decisions for the kids and they haven't appointed someone to make decisions for the kids, that's where you run into the most, difficult situations, because you would have family members attempting to ask the court for permission, and no one wants to be going to court while they're grieving a loss. And you would potentially have the office of the public guardian and trustee stepping in to make decisions for those children, which is good. They're protecting the kids, but it just complicates matters and doesn't have as much control. I mean, if these individuals, the Kapoors, want to make sure that they can control who makes decisions for their children after they pass and what those decisions are, they ought to be planning them out. When we have a family structure like this, it's really easy for us to lay that out really clearly in advance, make sure that those decisions are made the way that they want them to.
Perfect. Thank you. Yeah. Makes pretty good sense. I mean, it's you can be as simple or as detailed as you want in a will, but I've seen firsthand going through it that you get into those things that you haven't thought about, these types of scenarios, right? So, perfect. So, these scenarios really, their goal is to help us highlight some common situations that, even if you haven't seen them, you probably know somebody who has seen them or been impacted in these ways. So we've discussed some ways to prepare. Now let's take it a step further and explore how an effective estate plan is built to address some of these concerns. Next slide. Estate objectives, they're usually placed into the categories that you see on the slide there. So asset transfer, incapacity planning, charitable intent, and tax efficiency. Next slide. And we've touched on some of them already, but your plan needs to be customized, typically by a lawyer like Chaylene, and maybe a tax professional, again, depending on your situation, to address your assets and your goals in passing things on to others. And while the specifics of your own plan will vary, a properly designed plan will consider 3 action items. Number 1, defining your goals. 2, considering the risks. And lastly, developing a strategy. Next slide. So over and above lawyers and accountants, though, your financial advisor should absolutely play a key role in the planning process as well. Again, I can't speak for other advisors, so I'll explain what it is I do when I talk about estate planning. So first and foremost is defining goals, and this will include understanding the current situation. And by this, I mean assets versus debt, income and spending, current insurance coverage, any future known needs. Second, we'll outline key priorities and objectives, things like a desire to transfer assets to a family or a charity, protection against incapacity, tax control, or business succession concerns. Third, we discuss transparency to see if it makes sense to consider sharing the estate plan with beneficiaries. In my experience, it's very helpful, especially when there are maybe difficult personalities involved. People can change when real money is on the table. We've all seen it. And lastly is balancing competing goals. So maybe you want to focus more on spending your hard-earned money in retirement, but your spouse wants to leave more for the kids or to the University Hospital Foundation, right? So we discuss these trade-offs and some strategies to use in these situations as well. Next slide. So once we've got the goals sorted out, then I help consider the risks. And as we've learned today, risks are there. Unexpected events can derail even the best plan. So some risks to consider include obviously life events, changes in a beneficiary situation, like marriage, divorce, birth, untimely death, injury, or even a change in your own income needs. Government changes, tax laws can have a real significant impact, as we'll see later, and including these rumors we keep hearing about proposed tax on the sale of your own primary residence, right? This can impact the value of any estate. So, lastly, and we don't see this too often, but incorrect implementation of the strategy. So, technical issues, things like improper registration, inconsistencies among documents, improper beneficiary designations. A real easy story. I was sitting down with a client the other day for our annual review. We started talking about their wills, and the wife they're elderly couple, and the wife kind of nudged her husband, and in that I've been telling you to do this for a while kind of way. And he's having an issue because they haven't looked at their wills in over 30 years, and the lawyer they used has since retired and closed his practice, and he had their hard copies. So those hard copies were eventually shipped off to I believe a legal storage facility somewhere in Calgary. So he has to go down to Calgary with proper documentation, everything to prove that's his will, and pick him up. And he just hasn't gotten around to it. So little things like that are risks to consider as time goes on. Next slide. So lastly, we've got the goals, we've got the risks. Now it's time to develop a strategy that meets these goals while implementing safeguards against the risks. So the strategy, any good strategy, will include guidance on how to invest based on whether leaving a legacy is a primary or secondary goal, balancing potential issues and trade-offs regarding the different investment options out there, looking at insurance options to see if it's required to protect the plan, and reviewing, very importantly, reviewing beneficiary designations on investment accounts and insurance policies to make sure they align with the stated goals. So I'm going to pause here just for a bit to address something that I don't actually have a slide for, and that's special considerations for small business owners and people with sizable estates. Now, while I can't go into full detail on for respect to time here, there are some important estate considerations that are specific to business owners, self-employed professionals, or individuals with significant assets and more complex needs. Now, remember, an estate strategy, it's all about control. So in the case of a business owner, the question is, how do you want ownership and control of your business to be transferred? That transfer could be for any number of reasons, such as a planned exit or untimely death or disability, to name a couple. Unfortunately, though, only 30% of family-owned businesses continue into the second generation, and that's typically because the owner didn't prepare a proper estate plan or succession plan. Now, there are a whole lot of list of risks that I won't get into that are specific to business owners, and they're unique to each business. So as a result, it's vital to work closely with a lawyer like Chaylene, who's got corporate and estate expertise, and your tax professional, whether that's a tax lawyer or an accountant, and your financial advisor, to develop a proper succession strategy that's considered so many different angles that fits with your goals. Now, in terms of individuals with sizable assets and more complex issues, their needs are often similar to those with less complex needs, right? Provide for their families, protection against incapacity, and having guardians for their minor kids. However, relying on those basic strategies might not always be enough, and those strategies out there to deal with tax efficiency surrounding an estate often become much more important. And another important consideration and a big reason for this webinar today, and it can help with tax efficiency, is your charitable intent. Now, charitable giving is tax-friendly at any point, not just with estate planning. So I'm going to explain a few methods of giving that maybe you haven't heard about, maybe you have, but I'll get into some detail around it, and that are over and above simply writing a check. So first, we'll talk about in-kind stock donations, which can be done while you're still here. For those that maybe don't know, an in-kind stock donation is when you donate a stock that you own directly to a charity without selling it first. You pick it up from your account, you put it in theirs. Donating this way could result in pretty significant tax savings compared to just selling the stock and donating cash. Let's walk through an example together. Next slide. So here's a very basic example. Now, before we get into it, though, a couple of very important disclosures. So although I have experience here working on this and a working knowledge of tax law, I'm not a CPA. So any strategies like this really should be discussed with an accountant, your accountant, prior to implementation. They might make sense for you, they might not. these are very high level explanations that I'll show you. And their purpose is just to illustrate what happens when you donate investments in kind. Also, importantly, there are some changes coming next year specific to donations that will make donations less tax friendly in general. They'll still be tax friendly, but they'll be less tax friendly. So this example doesn't consider those changes, but it will look different starting next year. Now, of course, the main goal of giving isn't to get a tax break, right? It's to support an important cause, but the tax break is nice. So let's look at my my not very fancy spreadsheet here. Sorry, making things look pretty is not my my forte, but let's walk through the simple scenario. Now, keep in mind, I'm just picking easy round numbers to work with. So let's say you bought a stock at some point. You look at the second line there for 25,000, and however many years down the line, it's now worth 100, and you want to donate that. You have cash on hand to do it, but you want to keep that cash for something else. But you have the stock sitting there, and you've got a gain on it. So that gain is 75,000, right? Bought it for 25, it's worth 100. So if you don't know, half of that, the government is friendly with gains of this manner. So half of that could be yours if you sell it. The other half gets added to your income. Now, assuming you're at the top Alberta tax rate of 47%, you'd get charged 17,625 for selling the stock. You would also get a donation tax credit, though, equivalent to about half. Again, that will change next year. So on your $100,000 donation, if you sold the stock, the actual cost to you after all the credits and taxes and everything would be a little over 67,000. So your other option is to donate them in kind. And there's a form you fill out, and it just sends it right to the charity, and they can choose what they want to do with it once they get it. The benefit of this is, again, up until the end of this year, the government allows you to will actually waive any tax on that on the gain, right? So that gets flushed out to zero. So your actual cost of making a $100,000 donation is just under 50,000, resulting in pretty significant tax savings. So again, this is a real easy hypothetical scenario just to illustrate the point. And although the numbers are going to change next year, it will still be more friendly to do it this way than to sell and donate the cash. So I'm going to leave it there. And if you have questions, please put them in the chat or write them down, and we'll get to them at the Q&A section. But I want to move on as well to an estate planning perspective. So this is looking at what you can do while you're still around making decisions. But in terms of leaving a legacy, there are a whole host of options, but there are two methods that I want to touch on that incorporate a gift into your estate plan. So number one, easily, you can name the University Hospital Foundation as a beneficiary in your will. The percentage or the amount is obviously up to you, depending on all the other factors in your life, but it's a real easy way to leave the gift that you want and get a little bit of tax relief on your estate for the donation. Now, generally, it's a smooth process, but depending on the other people involved and how much you're leaving, things could get tied up or worse, contested by others before it gets paid out. There could also be other fees and taxes that come along with doing it this way. Again, depending on your situation. All that being said, it's pretty straightforward and easy to do. The other option, and my personal preference for leaving a legacy gift, instead of naming them in the will, is to take out an insurance policy and name the charity as the sole beneficiary. And there are a couple of reasons I like this option. Number one, there's no lag between death and payout. The claim is submitted by the executor of your will, and the insurance company cuts a check, tax-free to the charity. It doesn't go through the will, so no other beneficiaries can fight or argue it if you've got some difficult personalities somewhere, because they have absolutely no rights to it. So you'll leave the gift you wanted to, hassle-free. And secondly, this is where the financial advisor part of me comes out, but by naming a charity as a sole beneficiary, those insurance premiums, so the cost of the insurance, can be considered donations. So you could get that annual tax credit while you're alive and paying for the policy based on the premium amount. Again, review all this with accountants. It's important to do, but that's the general structure of how taxes work with this. So there are so many more options out there and a number of ways to structure them. So if you're considering leaving a gift of some kind in your will or another method, make sure you talk with your financial advisor so you can explore all those options. And if you don't have one or haven't considered looking for one in the past, please, my contact information is listed somewhere at the end here. Feel free to reach out directly and we can talk about it. Next slide. So I've spoken for quite a while, so I'll end my portion here by discussing a common theme in each of those scenarios we discussed, even though they have their own unique characteristics. And in a word, it's review. Developing a plan is step one, but the process isn't done. Plans need to be reviewed periodically and updated as changes come up so that everything still aligns with your wishes and what you want. It's a lot easier said than done because life gets busy and money just slips to the bottom of the priority pile pretty quick. But that's part of the value of having an advisor like me that brings to the table. We think about it and discuss it with you periodically so you don't have to. So that's it for me. Thank you all for at least trying to listen. And Chaylene, thank you for your input on my scenarios. I know you've got some more detail around the legal side of this and how to actually put these plans into action. So please take it away.
Awesome. Thanks, Mark. That was amazing. I was kind of laughing to myself. Mark suggested that he might be the one to make people's eyelids heavy. And I thought to myself, well, I'm about to talk about legal things, which usually isn't the most thrilling to most observers, but I'll try to make it interesting. So part of the reason that we have Mark go first when it comes to the financial planning perspective is because that's quite often how we operate. So very frequently we'll have your financial planner or your accountant work with you, basically ascertain your personal net worth statement, figure out what you want to happen with that worth, whether you want to move it around and do some tax planning or investments or insurance plans or anything like that before you come to us. And then we take that input and we work on the legal side. So we'll talk about a variety of estate planning topics today. We can go over to the next slide here. But the first that we'll start with is planning for a loss of capacity. So this isn't actually what people think about first when they think about their estate plan. They think about their will. And the questions that we asked at the beginning here are how many people have wills? I'd like you to take a moment and think to yourself whether that will was prepared by an estate lawyer or whether it was prepared by your corporate lawyer, or unfortunately, quite a few of them are prepared by an online resource. So that might be something to keep in mind, is whether you've had that proper planning and proper advice from an estate lawyer. The second thing to think about, though, is whether you also have a personal directive and power of attorney. So when we're dealing with a will, we're dealing with someone who's actually lost their life and dealing with what their estate will do after they are deceased. But at this point right now, we're talking about a loss of capacity. So that loss of capacity can be temporary or permanent. And we'll talk about the planning methods for a loss of capacity on the next slide here. So in order to have the capacity document spring into place, you would require a declaration of incapacity. And I'll use several acronyms throughout the presentation here, but we'll get familiar with them really quickly. We've got the power of attorney, the POA, and the personal directive, or the PD. Those are the two loss of capacity documents. Both of them discuss what happens with your estate or your personal decisions in the event that you are incapacitated. You might think to yourself, okay, well, they'll spring into place if you've had an injury or an illness that renders you incapable of making decisions for yourself, but they're also very helpful at end of life. So in the event that you have dementia or you're placed in a home and unable to make financial or health decisions for yourself, that's where the power of attorney and personal directive come in. You can do an immediate power of attorney in the event that you want people to make decisions for you for a power of attorney instantly. But generally speaking, they spring into place, and that's why they're called a springing power of attorney in the event that you're incapacitated. The very first decision that we speak about with our clients is, what do you want that declaration of incapacity to look like? And I actually spend quite a bit of time on this because people will often default to one physician or their agent, which is the person that they're appointing to make decisions, as the individual that gets to declare them to be incapacitated. But we like to discuss what that might actually look like at different stages in your life. Generally speaking, we recommend 2 service providers, at least one of whom is a physician or a psychiatrist. And there is a difference between psychologist and psychiatrist for the purposes of these decisions. And those individuals are the ones that should make the decision that springs your power of attorney and your personal directive into play. So then the next question is, what does that declaration mean? Well, the declaration of incapacity means that your power of attorney or your personal directive, and I'll explain in more detail what the difference is, now apply. And that means that others are making decisions for you while you're incapacitated. That's why that declaration of incapacity is extremely crucial. You want to be careful about when that declaration happens. Next slide, please. Okay, so first we'll talk about the power of attorney. The power of attorney, it's a complex document, but relatively boilerplate. And that means that most of them look essentially the same, despite the fact that they are complex, and the decision is really important. So within your power of attorney, you appoint someone called an attorney, and it gets a little bit confusing because, of course, American media refers to lawyers as attorneys, not so much Canadian, but just keep in mind that when you're talking about Canadian law, your attorney is your attorney under a power of attorney. They can also be referred to as a trustee because they are governed by something called the Trustee Act. But what it really means from a layman's perspective is that your attorney steps into your shoes and they make the decisions that you could have made had you had capacity. So they make decisions with respect to financial matters, financial matters, property, businesses, and legal matters. That means that they can really mess up your estate if you appoint the wrong attorney. They can shut down your bank accounts, they can move those funds around, they can sell your home, they can run your business. All of those things mean that these are very important decision makers. So if you have your screen display such that you cannot see the words on the right hand of your screen, that says the theme here is trust. When we're asked who to appoint under a power of attorney, we always just ask the individuals, who do you trust the most to make these decisions for you? Now, the other thing that we'll talk about often is standard of care. Under the Trustee Act, and I'll try not to get academic on this, but the standard of care that your trustee has to act is basically that of an investment advisor. So Mark could easily tell you he's held to a really high standard of care when it comes to your finances, and it can be quite onerous if you're not a professional. So depending on who our clients appoint to be their attorney under their power of attorney, we often discuss reducing that standard of care to the duty of honesty and good faith. And that enables your attorney to hire the professionals that will help them make the decisions under your power of attorney. So they'll speak with financial advisors, with tax advisors, with lawyers to make decisions that work for your estate and preserve it. We'll go to the next slide. Your personal directive is slightly different. So your personal directive applies to your personal matters. People think of end of life here. In the States, they call them a living will. There's a variety of other terms for your personal directive, but that's, what kind of extraordinary measures are people able to make upon your incapacity? And if you're ill and you require, say, a feeding tube or something like that. We can get extremely specific over what is permitted or what is not permitted. But the decisions that people forget fairly frequently that your personal directive also applies to are the decisions about with whom you associate, so who can visit you in the event that you're in something like a nursing home, whether you should be placed into a facilitated care facility, and whether you can still drive. So that's one of the earliest and most difficult decisions that your personal directive governs, is when to take away your driving privileges and your keys. Under your personal directive, you're appointing an agent. So that's what that individual is called. It's kind of funny. It's sort of like a CIA appointment. But this person makes the decisions for you under your personal matters. You can imagine already that it might not be the same person as your power of attorney. They're making very different decisions. It requires a very different skill set. But of course, you want to trust this person as well. We very frequently have people asked to appoint joint agents because this one is a little bit more emotional. So they may wish to appoint joint agents who are both or several of their children. We do speak with our clients quite firmly about the appointment of joint agents, joint attorneys, and joint executors, because it usually means that the decisions have to be unanimous. When it comes to your personal directive, decisions have to be made really quickly, quite frequently. So we generally recommend only one agent with an alternate. Next slide, please. Okay, so those are the incapacity topics. Moving on to a loss of life. This is more in line with what Mark was discussing. And you probably already sense this from my answers to the scenarios, but the main theme here is control. How much control do you want to have over your estate after you pass away? We absolutely have clients, and some of them are extremely high net worth, that don't want that much control. They appoint their executor and then they move on. So we'll go to the next slide here. Okay, so we're talking about a will here. People are much more familiar with that. But what some people are not as familiar with is what doesn't actually pass through your will. So these are items that are dealt with completely outside of estate law. That is jointly held property here in Alberta, specific beneficiaries on things like RRSPs, TFSAs, any other registered accounts and insurance plans. In some cases, unanimous shareholder agreement property, and I'll expand on that in a moment. And in some cases, property owned in a trust. So without getting into all of the nuances of corporate law and securities, when you own a business with another individual and you have a unanimous shareholders agreement, so a USA, those pieces of property could be governed by that USA, and any property within that business could be governed by that USA as opposed to your will. The other is property owned in a trust. So we do family trust quite frequently, and those types of property pass through your will differently and are dealt with in estate law differently. We'll go to the next slide. So everything that does pass through your will, these are the items that we like to run through with our clients. And this is a very brief overview. Normally, we would spend about an hour in the initial phone call, making sure that we understand the client's objectives and concerns, because that's going to set the framework for the entire drafting process. So just running through will very quickly, one of the initial things to talk about is intestacy. That just means that you've passed away without a will. So in the event that you pass away without a will, your estate is governed by the Wills and Successions Act. That can be totally fine, honestly. It means that your estate generally would go to your spouse or your adult interdependent partner upon your death. They would have to govern it. They would have to administer your estate. In the event that you're not married, that's where it gets a little bit tricky because it could go to your parents, which isn't necessarily what you want. If you have adult children and you're not married, it could go to your kids. So those situations are generally okay. It just means that you don't have control over what happens to that estate and over who has to administer it. The other issue with intestacy is that if you pass away without a will and you have an estate of basically any size or have any sort of real property, someone now has to apply to the court for something called a grant of administration. So they have to convince a court that they are the appropriate person to administer your estate because you haven't appointed them. So then it's really up to the court to decide whether they are appropriate. Again, probably doesn't sound that onerous, but it gets really difficult when we have, a grieving spouse come in and say, the bank won't talk to me because I'm not appointed under a will. So then we have to go to court and get them those rights. And I will say, paying legal fees, having to talk to me, and going to court as a grieving partner is really difficult. So having a will just makes that all a lot more streamlined. When it comes to your will, there are very strict technical requirements. That's our job to know. The only one to flag to you is something called a holograph will. So you might think that you're okay because you've handwritten a will out and it contains all of your dispensations. A holograph will is actually one of the cooler areas of estate law, but it means that you've handwritten the entire document and you've signed it. There are really easy ways to do that wrong. And usually if you've handwritten the entire document, it doesn't contain everything that we want it to contain. So our typed up wills are usually anywhere between 8 to 15, sometimes 20 pages. And I doubt you're handwriting all of that out. So that is possible to have a valid will handwritten, but it's not usually recommended. I will say that the biggest estate fights that I ever see, the ones that have cost our clients hundreds of thousands of dollars in legal fees and appeal after appeal, are over holograph wills. Under your will, you're appointing your executor. That's how a lot of people refer to it. There is sort of an antiquated term called executrix. We're trying to be non-gendered in 2023, so we usually refer to them just as your executor or your personal representative, and that's how the estate legislation refers to them. They are also a trustee, so those words are used interchangeably in estate law for many purposes. I'll caution you about joint executors again for almost the exact same reason as the personal directive. Those end up in fights. I would say 10% of the joint appointments that I've seen have gone smoothly. So that tells you how many end up in fights. The other note is that if you're appointing a executor or a personal representative who's out of province, the court actually has additional requirements for that, and they're financial. They usually require that person to pay a bond into court in order for that person to have control over your estate. So we like to avoid that as well. Mark referred to someone taking care of your kids. So that appointment is usually within your will. That's where you appoint a guardian or guardians. And you might think to yourself, that is such an easy decision, right? You might think, okay, well, it's my brother and his wife are going to be taking care of our kids in the event that they pass. They're really close to their cousins. It is, unfortunately, my job to think about the worst case scenario. So I'll ask you questions about, okay, well, what happens if they divorce? What happens if they're just separated but not divorced? What happens if your brother passes away but his wife is still living? What happens if your kids are 16 and you don't really want them to have to go live with your brother and his wife? So those are the decisions that we talk through, those nuances. That's where a guardian appointment might be a little bit more nuanced than people think at first glance. And then the last is your funeral instructions. People are very often surprised when we ask them those questions and what they want to put in their will. So it's not legally binding, but we usually do put a funerary instruction within the will. It's honestly a courtesy to your executor. People are very often wondering, okay, well, what do they want done with their remains? And the more specific that you can be in a will, the less the executor has to guess. Next slide. Okay, so I won't go through all of these on this slide because I am being cognizant of time here, but these are the various topics that we often refer to in our estate planning sessions and within your estate plan itself. So we talk about your estate, we talk about named beneficiaries and joint ownership. So those are the things that pass outside of your will, but we'll usually do almost like a catch-all provision, which basically says in the event that I have anything that's registered and has a named beneficiary, that the named beneficiary cannot receive that gift, here's what I want to happen. We deal with something called specific bequests. That's just gifts. So that's where we will often find charitable giving in the event that you want to gift shares or a set financial amount to a charity. It's where you put, your engagement ring to your eldest daughter or whatever the case may be that you want to appoint within that specific bequest section. Then we talk about your personal items and how you want those to go. And again, worst case scenario, we come up with a mechanism to determine what happens to them if there's a fight as amongst your family members. And then we get into your residuary estate. So that's everything that's left after those specific items have been dealt with. Usually what we'll deal with is children in a staggered trust. So if someone's under 18, we will create a trust with you and determine what those children will get at what ages. There are tax considerations within those trusts, so we are alive to that. We always recommend tax advice and getting it blessed with your accountant as well as us. We're certainly very respectful of our financial advisor and accountant pals when it comes to estate planning. So that's what we'll usually deal with in the staggered trust. We deal with family trusts if we are doing that with the financial advisor. But usually what we spend the most time talking about is common demise. So that means everyone very sadly and unfortunately passes away. What do you want to happen with your estate? We often see charitable giving there as well. So both specific bequests and then common demise. But those are the tough conversations that we have to have. We talk about business assets and share distribution, and then we talk about key man insurance if you do own a business. The reason we talk about that is because what happens if you own a business and you're a key man within that business, i.e. you're required to run it and you pass away, we want to make sure that there are some funds flowing into that business to buy your shares from the estate so that the estate is not left high and dry. Then the last thing that we discuss, which is not legally binding, but we do offer, is a memorandum of personal effects. So that's a separate document that you can use to advise your executor, here's what I want to happen with my buffet that was passed down from generation to generation. Next slide, please. These are the tips and tricks and practical solutions. So I can talk about the law all that I want. But what we're really trying to figure out is what you want your legacy to look like after you've passed away. So we correspond with your financial advisors. We take a look at your personal net worth statement. If you don't have one already, we help you create one because we want to make sure to get that snapshot of what you have. We talk with your financial advisors and your tax advisors about whether you should be making something called inter vivos gifts. And I laughed as I was putting that in here because it's tough to get through a legal presentation without any Latin. So I'm sorry for that. But what that means is while you're still surviving, whether you want to give pieces of your estate away, and usually there are tax reasons for that. We talk about divorces of your beneficiaries or guardians. We talk about corporate executors. So whether you want a corporation to administer your estate as opposed to an individual. We discuss joint ownership and whether property should be put into joint ownership before you pass away in order to reduce some of the tax burden. And really hot topics, we always recommend family meetings in the event that your children are getting to kind of that 14 plus age, talking with them about what they want things to look like, especially if you have a business, talking about whether they want to be involved in it after you've passed away. Then we get asked all the time about how do I protect my legacy to my children? So we very frequently end up consulting on cohabitation and prenuptial agreements for the children of the testator. So we have an in-house family law expert and they assist with that. Go to the next slide. Okay, so I think we are 2 minutes shy of 4:30 and I'll take a break to answer any questions along with Mark.
All right. Thank you, Mark and Chaylene. That was fantastic and a top-flight lesson in estate planning. It's given us a lot of valuable information to consider today. It's now time to open the floor to our audience for our Q&A period. With that, I'm going to turn it over to my colleague, Manager of Corporate Partnerships at the University Hospital Foundation, Sean McLaughlin.
Thank you, Sean. Good afternoon, everyone. I hope you've enjoyed the presentation as much as I have today. It's been quite fantastic, and I want to thank Chay and Mark again for their time and for coming on board as sponsors of this event as well, which is fantastic. If you haven't submitted your questions already, please do so now. I'm looking at the Q&A as we speak, and we'll read out some of these questions to our guests here. All right, so our first question here, they hope it's not a dumb question. I think I've been told many times there's no such thing. Life and situations are always changing. Is there a way to make small changes to your will? As an example, a change of who you are giving a charitable gift to, or the amount, or changing your power of attorney without paying big legal fees through a lawyer?
Yeah, I think I'll take this one unless Mark wants to give it a shot. No, absolutely not. Okay. There are definitely ways to do this. So we get it. You don't want to be paying thousands of dollars every time you change something small. Generally speaking, we'll give our clients an option. So I'll talk about the lawyer route first and then talk about how you can do it yourself, which I probably shouldn't be doing, but we'll do it today. The lawyer route first, if someone comes to me with something very simple like that, I'll say, listen, we are obligated to go through the entire document and tell you whether anything needs to be updated. If you don't want me to do that, tell me that in writing, and then we'll just draw you up a brief addendum, or what we would call a codicil when it comes to estate law. So that's something that's a page long. They can sign it in their home. They just need to have a couple of witnesses. We help them with that. That goes for your will or your power of attorney. I will say the power of attorney and personal directive are much easier to change, so long as you haven't been declared incapacitated yet. So of course, things get a little bit more tricky once you've lost capacity. When it comes to doing it yourself, I will occasionally refer clients to some information on how they might change something themselves with just a couple of, words handwritten on a piece of paper. We always caveat that and say it's not guaranteed it's enforceable, and it's not guaranteed it won't cause a fight. So our recommendation is always to do it with a lawyer, but there are ways to do it yourself.
Excellent. Thank you. All right. Next question here. For a 35 to 40-year-old, what would be your advice to them on wills, especially those with investments in cryptocurrency?
I'll take this one as well, Mark, probably. So I really like this question from an estate planning perspective. We are, of course, dealing with all sorts of novel issues. I would say two of the more hot topics that we're dealing with right now are cryptocurrency and also cryogenics, which is not something I thought I'd be getting into as a lawyer, but I absolutely love it. We would be providing a wealth of advice. The one thing I will say is that you'll want to make sure that your will has a pretty robust provision when it comes to, digital property and intellectual property. The law is a little slow on catching up to what you guys are doing in the investment sphere, so we have to be creative in our drafting. I think our intellectual property provision is like a half page long. Like, it's quite a bit of drafting to make sure that what's happening with that is what you want to happen. We would also be advising you with respect to password storage, access storage, how to speak with your investment advisors to make sure that those crypto holdings, if they're through an investment advisor, are dealt with the way that you want to.
Great, thank you. All right, next question here. Can you advise how the new AMT tax is going to make significant impacts on planned estate gifts? Or does the AMT only apply to stock donations?
Yeah, I'll get into that as much as I can. So, like I said earlier, I'm a tad limited on specific tax advice. I mean, if we're just sitting down in a room with no recording, that's different. We can talk a little more, but I'm not a CPA, so I double check everything with an accountant. But my understanding of the proposed changes is that the capital gain waiver there on donating something in kind, whether it's a stock or an EFT or an ETF or a mutual fund or some other investment, donating it in kind, if there is a capital gain, they don't just wipe out the amount that's exposed. They're going to drop it to, increase it to 30%. So if you have $100,000 worth of gains, that up until the end of this year, those would be forgotten about on an in-kind donation. 30% of that gain, or $30,000, will be added to income, and you'll pay tax on whatever it is. You'll also only on the donation credit, the tax credit that's received, because that's different than the capital gain tax waiver. The credit that you'll receive is being reduced. It's based on a formula and what your income level is, but so they're making it less tax friendly across the board, and I believe the idea is to make sure everybody pays a fair amount of tax. I won't get into my opinions on all of it, but again, for specifics, I suggest reaching out to your accountant when you're looking at actually processing the transaction.
Great, thank you. All right, next question here, I think we'll go to Chay. Is there an advantage in working with a large legal firm versus a smaller legal firm?
Yeah, really good question. So I'll answer this from an estate planning perspective. I think my partners at the firm would probably say, about 50 lawyers is great, especially if the name starts with a B and it's us. But that's not a very fair answer. So It's a nuanced question. A lot of people think that if they're going to a smaller legal firm, particularly if it's an estate boutique, I worked at one of those during law school and it was awesome, that would be the bigger advantage. And for a simple estate, it's awesome. Even for a complex estate, it's a really good idea because they are experts in their field. The reason that I do recommend that you at least consult with some larger firms, so again, we're about 50 lawyers, 120 staff, so in Edmonton, we're considered pretty big. The reason that I do recommend consulting with us or another firm of our size is because we have the corporate and family law experts as well. So if you're at kind of a 6-7 person estate boutique, they're not going to have that. But if someone comes to me and they're talking about all of their estate plan, I can refer them to our corporate team or even just pull in our corporate team on a gratis level to speak with them about their USA and business holdings. And I can pull in our family team as well. So we just like that because we're really team-based. I can't speak so much to the uber large kind of nationals such as, Dentons or Bennett Jones. They're awesome law firms. I expect they'd be able to do the exact same as we would. It's just a little bit different because they deal with corporations a lot more than individuals. So estate law is a bit less their bread and butter.
If I could hop in just for a half second to
Sure.
kind of tag on that. Again, just referring back to the story I told earlier about that elderly clients, right? That just again a technical issue. These are rare things that happen, and ultimately, it comes down to personal preference and who you get along with and who you trust the most. But yeah, a little issue like that. These people don't have the hard copies of their wills. They have to go down to Calgary because the firm that they were using was a one-person firm, and when he retired, he closed the doors. And the will's been shipped down to Calgary. So it's creating that issue now at the end of it. So again, personal preference, but yeah, there's risks associated that need to be considered.
Fair enough. All right. Next question here. Is it too early to be thinking about making a will in my mid-20s?
What a good question. And I also love that someone in their mid-20s is attending this presentation for a variety of different reasons. I think that's great for the UHF. So thank you for attending. Okay, time to come completely clean. I don't have my own will, and it keeps me up every night. But part of the reason that I didn't is because for, most of my professional career here, I did the exact same thing that Mark talked about in his scenarios. I wondered to myself, well, I don't have an estate. All I have is mountains of debt from law school. So I wondered to myself, why would I need a will? I don't have kids. I don't have a home, or I didn't at that time. Really, it comes down to that administration of your estate and who makes decisions. Now that I've seen it go sideways more times, I mean, even if I didn't have an estate, someone would have had to apply to the court for the ability to administer my student loans. Someone would have had to apply to the court for the ability to make decisions on my bank accounts. I would much prefer to streamline that and to tell the administrators of my estate what I want that to look like. I want that control. So listen, in your mid-20s with, limited assets, perhaps, and depending on whether you have kids, it can be pretty simple, but at least then you have that peace of mind and you know that your grieving family won't have to be struggling to figure out what you want.
Great, thank you. All right, another end of a spectrum here. For a 90-year-old with great assets, very philanthropic, would you advise holding on to his assets until passing or giving more of it away during his lifetime?
Yeah, there's that's one of those ones there are a lot of different answers, and it's very unique to the rest of the scenario. So there's a lot more information that I'd want to get into to be able to provide any kind of proper answer, and more people that I'd want to consult with. If you want to save more taxes while you're living because you consistently deal with a high tax bill, then likely not wait until the end of life. Or if you want to, and something I'm seeing now, about 75% of my clients are in that baby boom or silent generation. Something I hear more and more is we want to gift money to our kids now while we can watch them use it and watch them enjoy it. So maybe that's part of it as well, is you want to, maybe you love the SPCA or the Humane Foundation and you really want to make a difference, and you can donate a sizable chunk and watch what they do with it and be involved in all that. And when you're gone, you can't watch it, right? Now, granted, there are some extra tax benefits available. Again, I don't know how this will be changing with next year, but in the final year so your final taxes, the donation tax credit is heightened, right? It's a little bit higher, so there may be a way to ease the tax burden on the estate. So the first thing that comes to mind is there's probably a happy compromise between both of those options given, but there's a lot more information that I'd want to know about that person to see what they really want, and then come up with strategies to sort that out.
Yeah, and sorry, Sean, I'll just hop in on that one too, very, very briefly. I agree with Mark 100%. I would say this is almost always driven by tax and accounting advice. But where we come in as well is with respect to how simple you can get your estate. So if you are elderly and or being more respectful of an advanced age, and you wish to make your estate very simple for your executor to deal with, we will often speak with you about, putting things into joint ownership so that they pass outside of your estate, giving things away or donating things earlier in your life so that they're not dealt with in your estate. We like that. I think charities generally are fine with that as well. So we're happy to help you make things simple and make sure that everything goes the way that you plan.
Wonderful. All right. Next question here. Could you speak on the issues related to having an executor residing outside of the province? And do executors have to be related to you?
Yeah, I can speak on those two really quickly. So I'll answer the second one first. Do executors have to be related to you? Absolutely not. And sometimes that's not the best decision for you. So we would talk through sort of the consequences and considerations for who to appoint as your executor. You can appoint many individuals. It's always good to chat with them first, but it's not required. And then you can also appoint corporate executors under certain circumstances. The second question about your executor being located out of province. So I spoke very briefly about the court requiring a bond in those situations. To be honest, the other consideration is that it's just sort of annoying for your executor because they're having to correspond with out of province entities. It happens much more frequently now, and it's much more accepted now just because of the digital modes of communication. So we caution about it a lot less than we used to. We used to really caution against it.
That makes sense. Thank you. All right. Last question I have in the live Q&A here, so hopefully we have a couple more come in. Can my will be contested if my kids feel that the distribution was not fair?
Yeah. Yes. The short answer is yes. But it's not just your kids. It can be any interested person. So your kids are very frequently the ones who contest a will. It can be your partner, your adult interdependent partner, used to be called a common law partner, or it can be your spouse. It can also be other interested persons. I mean, we've seen them with grandchildren that are dependent upon their grandparents financially. That all comes from the Wills and Successions Act. From a litigation perspective, so a court attendance perspective, they are very interesting files. Part of the reason that we like them is because they're complex, they're somewhat emotion driven, and they cost a lot in legal fees. So this is part of the reason that we try to avoid them when we're estate planning, because they are incredibly expensive. Because we have a few more minutes and we haven't told any stories yet, I can tell one that's public because it's court filed documents and my name's on them. So it's no secret that I was acting on the file. My largest estate litigation file was basically an episode of Yellowstone. We were dealing with a massive cattle ranch. There was an alleged murder of the testator by one of his children. We had a current romantic partner. We had a former spouse. It was an absolute mess. It went to court. Oh gosh, I think we were in court kind of every second week for a couple of years. We eventually got a decision. It got appealed to the appeal court, and it's been sent down for another trial. So we'll have to go to court again. Ridiculous amounts of legal fees. I will say part of the reason that one was so messy was twofold. First of all, there was a handwritten holograph will that was literally the size of a note card. So don't recommend that. And second of all, it was a lucrative farming estate. And we had lots of kids who were interested in it. So those are really complicated. We try to avoid that in the planning process.
Great, thank you. We are getting a couple more questions in here. In today's volatile markets, what happens after my death if my assets have lost a great amount of value due to the markets?
Yeah, I don't know what volatile markets you're talking about. It's been perfect. No, it'd be nice if it cooperated once in a while. Yeah, so great question. There are certain ways to lock in values and have that reset. And so you do get a guaranteed value every X amount of years. You can reset when it gets up to a certain level and lock that in. Those are pretty structured and not for everybody, but those products exist. There are also, it always depends on the situation, right? So let's say this hypothetical scenario, this person has 2 kids and it's very clear it's 50-50 to their kids, no spouse to pass it on to. Then whoever the executor of the will is brings in the proof to me, everything that I need on my end to process whatever I need to process. And the executor can kind of decide, do we want to hang on and let things recover, or do one of us or both of us, both the beneficiaries, need the money, or how do we sort this out? It's sort of up to the executor at that point, unless it's pretty implicit in the will. So another example could be if you had minor dependents and it was left to them, and you had it listed in there that funds are to be made available at this age for this purpose, and then at this age, so in stages for different purposes. Then again, the executor, depending on how many years are between death and when this stuff gets paid out, the executor kind of has control, working with the financial advisor, on what do we invest into? Do we keep it invested? Do we go to cash? What do we do? So yeah, there are again variables to that answer, but it depends on how the executor runs it based on instructions on the will.
Great, thank you. All right, next one here. Mark mentioned gift of insurance ownership. Is it a win-win for both my estate and for the charity?
Yes, it gets a little murky where if you're claiming the insurance cost along the way, does the payout act as another tax deduction, right? Are we kind of getting double tax benefit? So it can get a little murky there, again, depending on the insurance product, if it's your standard term policy or if it's a permanent policy that has a cash value associated with it. Then we get into capital gains on those cash values and capital losses. So it can get murky, but typically it is. But again, that's where an accountant is going through the numbers and earning their weight in gold to sort it all out in that final year of taxes. And there are other ways to structure it too. Like, for example, there's something called a donor advised fund that you can contribute to while you're alive. You set it up, and it's essentially a bank account for a charity that you set up. And so you put the money in there, you get the donation tax credit. And once money's in there, it's in there, right? You do this while you're alive. Once it's in there, but it gets invested, and then you can choose where money goes to, what charities they go to, and set that all up. And it can be another way of creating this lasting legacy. Let's say you want to put $100,000 into it over 10 years and it stays invested forever and it's, pays out 5% interest a year. I'm just making up easy numbers. Even after you're gone, it's continually paying out $5,000 a year. And again, just making up easy numbers, but there are ways to kind of get a win-win for everybody. Yeah.
That's great. That was actually a 2-for-1 answer because we did have a question about donor advised funds as well. So well done. Bonus points for you. We've heard a lot of great information today on getting started with the creation of a will. What could someone expect for the cost to get started, and what would be the first step they would need to take? Chay, I would assume that one's going to you.
Yeah, for sure. I think that my question thing is broken too, so I can't see that one. So Sean, please let me know if I miss half of it. The cost question is the bane of lawyers' existence because we don't know until we know if we're setting up a trust. We don't know until we know if we're consulting with your tax advisors or consulting with a corporate executor. Those things all usually run up the cost. Our firm bills by the hour, so most law firms do. That's no surprise if you've ever seen a lawyer movie or show. But there are firms that have a flat rate for estate planning. I don't actually like doing that because quite frequently I can do an estate plan for less than a reasonable flat rate would be for the firm to remain financially lucrative. But usually what we would do is have that initial consult with the client and let them know what we expect to see. And Sean, can you give me the second part of that question, please?
Yeah, absolutely. So it was just cost to get started and then the first step they would need to take.
Oh, yeah. Okay. So that's a little bit easier. Usually the first step to take is to speak with your financial advisor if you have one. We always recommend that first. They usually have lawyers that they work with frequently. If you have a lawyer you're already working with, then of course you're going to have a conversation with that individual. But if you don't, chat with your financial advisor, chat with your accountant. Usually what we would do is have someone send an email to the lawyer to set up an initial consult call. Generally speaking, they should schedule that for kind of that 30 minutes to an hour long, talk through your objectives, and then they would start talking with you about what the draft might look like. Everyone does it differently. I have questionnaires for clients depending on how much they want to do homework to keep legal costs down. I can do it all by way of virtual or in-person meeting if they want to run out more legal fees, but want to have that kind of more personalized experience. We work for you, right? So keep an eye on your lawyer, providing the service in a way that makes sense for you and makes you feel comfortable with the planning process.
Excellent. Thank you. I think we have time for maybe one, maybe two more here. Is it possible to get an estimate of my potential tax liability at death? How much my estate would be left with after factoring in philanthropic gifts that I'm considering making?
Yeah, it is possible. And there's a lot of work that can go ahead of time that can be done ahead of time to minimize that tax liability. Things like when and how much do we pull out of our registered accounts because that's taxable income. Do we start drawing that early or do we wait? There's a lot of that gets factored in. And the second, I was going to say for the second part, but that's all kind of one question. It's possible to get it, and we can work within kind of what we know right now and make as many assumptions as we can. Now, this is where I will sit down, and I've done this countless times. December is usually a busy month because we're trying to sort out how much can we get out of our retirement accounts without bumping into another tax bracket. Because we're trying to reduce the liability on the estate, right? So if you're solo, or even if you're married, so if one partner passes away, all their registered money slides over to the other partner, and there's no taxes to be paid on that. It goes from RSP or RIF to their RSP or RIF and just slides over. But if you're on your own or both pass away at the same time, then it all comes out in one big chunk. And if you've got $1 million sitting in your RIF or your RSP, that all gets added to your income. I showed you what the top tax bracket was here in Alberta. So you can wave bye-bye to 47% of that with some shrewd accounting. Maybe you can knock a few points off. So, trying to be proactive about taxes and drawing down those RSPs and RIFs in years where you have lower income, or just playing with tax brackets, is a plan that I'll put together, and then I'll actually call their accountants. Typically, they're my accountant that I work with, and we'll run through the plan, all of us together, to make sure we're doing the right thing and review it periodically and just adjust numbers as needed. So you can get a bit of an estimate, but there are a lot of assumptions at play, and a lot of work to be done ahead of time to reduce that bill.
Well, that's fantastic. All right, we are up against time here, but we do have one more question, and it is important. How do I make sure a specific gift or legacy will be paid out to the right charity? And I assume they mean the University Hospital Foundation.
Yeah, always, obviously. That's a really easy one to answer, so I can do it quite quickly. Usually we would put the registration number in. So I'm assuming you're asking legally, financially, how to make sure it goes to the right charity. So we would describe the charity, we would say their current location, we would sometimes run a charitable registration search, but most charities have their registration number on their website, and we would describe it in as much detail as humanly possible. If you mean ethically, how to find the right charity, examples are presentations like this. I mean, get familiar with those charities, go to their seminars, go to their speaking engagements. We really like following people on LinkedIn and social media to see what kind of the voice and personality of that charity is. And that's how you can find the right choice for you.
Excellent, thank you. All right, so thank you to everyone for the questions. That is all the time that we do have. And I'll welcome back Carolyn to close our program.
Okay, thank you, Sean, and what a great afternoon this has been. On behalf of Sean Price and Sean McLaughlin, Emily, myself, and of course our very special guests, Mark Claffey and Chaylene Gallagher, thank you for your time and participation. We hope you found today's session informative. We also want to give a special thanks to our presenting sponsors of today's virtual estate planning seminar, Bryan and Company, LLP, and Edward Jones. Now, within the next few days, we will send you the recording from today's seminar, along with a short survey for you to let us know how we did. Please feel free to share this recording with friends and family. If you want to learn more about us, please visit our website at give2uhf.ca. And if you would like to receive information on leaving a gift in your will to the University Hospital Foundation, please visit the Contact Us page of our website, where you can send us a message and where you will find our phone number, which is 1-833-448-3843. You can also watch recordings from other virtual events on the University Hospital Foundation's YouTube channel. Now, today we learned how including a gift in your will can have incredible tax benefits while making a major impact on healthcare at the University of Alberta Hospital site. I am proud to share that in the last 5 years alone, nearly $15 million from generous donors have left as gifts in their wills, which have supported the advancements in patient care and research at the University of Alberta site. Thank you so much for joining us today. And to conclude, we leave you with a 1-minute video about the University Hospital Foundation. Have a wonderful evening, everybody. Thank you.
As the need for change in healthcare grows, the University Hospital Foundation will continue to champion an impactful transformation, rising to face the challenges of today and tomorrow. Powered by our community and committed to creating a unified movement that ignores limitations, supercharges collaboration, inspires, connects, and enables world-class hospitals and healthcare teams to dream big, to cure disease, to revolutionize treatment, to spark clinical innovation, to to prevent illness before it begins. Because at the University Hospital Foundation, visionary solutions aren't science fiction. They're how we transform and redefine health so that everyone may live happier, longer lives.